Very good morning, sir. Jain sir, very good morning, sir. Myself, Dr. Piyush Verma, Registrar Guru Kashi University, sir.
Thank you. बहुत धन्यवाद.
Uh, Good morning, respected dignitaries, esteemed faculty members, dear students, and my dear colleagues. Today, it's indeed a matter of immense pride and privilege for Guru Kashi University to welcome very eminent and distinguished public figure of our country, Shri Satya Pal Jain ji. Jain Sahib is not only a distinguished senior advocate of Supreme Court of India, but the Punjab and Haryana court also. Apart from that, he is also additional Solicitor General of India, a position of the highest trust and responsibility, where he represents the Union of India in crucial matters of law and governance. Since his appointment in 2015 as the first ASG, for this reason, he has been the forefront of handling the government of India's litigation, guiding a panel of over 100 advocates and shaping legal strategy in the matters of national importance. Beyond the courtroom, Jain Saab has made a remarkable contribution to public life. He has twice been elected as a member of parliament from Chandigarh, where his work earned him a deep respect. He has been a key member of the BJP National Executive Committee since the year 2000 and has served the party in several significant capacities, including as a chairman of the National Committee for Legal Affairs and Election Commission issues. His intellectual contributions were further recognized when he was appointed a member of the 21st Law Commission of India, where his legal acumen enriched national policy and legislative reforms. But what sets Jain Saab apart from is not just the position he has held, but the exemplary integrity and unwavering commitment to justice and public service that he has consistently demonstrated. He stands as an inspiration for young lawyers and students alike, a living example of how dedication, discipline, and values can shape the truly meaningful career in law and public life. On the behalf of entire Guru Kashi University community, I extend very warm welcome to Shri Satya Pal Jain ji. We are deeply honored by his gracious presence and look forward with great anticipation to this illuminating lecture on litigation, career as a counsel for the Union of India, responsibilities, reflections, and the road ahead. His words today will undoubtedly leave a lasting imprint on the minds of our students, faculty, and everyone present here. Sir, we express our profound gratitude to you for accepting our invitation and blessing us with your time, wisdom, and presence. Thank you very much, sir. Now, may I request Mr. Gurneet to please throw a light on the today's webinar. Mr. Gurneet, please.
Sure. Good morning to everyone. It gives me immense pleasure to welcome you all to this very special lecture to be delivered by Sir. I think for young lawyers and students, today's lecture carries particular significance. Litigation career otherwise is seen as an individual pursuit only, which is built on one's own cases, briefs, and clients. But when one steps into the shoes as the Counsel for Union of India, the responsibilities truly transcend the personal. Each matter touches upon questions of public policy, governance, constitutional values, and the rights of citizens of our republic. Therefore, the art of advocacy in such matters is not just about legal strategy, it is about the credibility of the union and the faith of citizens in the justice delivery system. On a more personal note, this session holds special meaning to me. I have had the privilege of, in fact, working in Sir's office for over a year during my final year of law school. Because of COVID-19, my university's lectures had shifted online. But this unfortunate pandemic fortunately allowed me to extend my opportunity to intern in Sir's office for over a year. Those months have been a turning point in my own understanding of law and ethics. I not just learned on how the union navigates complex legal matters in court, but also the discipline, preparation, and sense of duty required of those who represent the union. I came to appreciate what it truly means to see the other side of the coin in litigation, how prosecution of a case is truly approached, how the union weighs competing interests, and how decisions must always be tested against the larger public interest. It is rare for students and young professionals to get such a view on how the state functions in litigation, and I remain truly grateful for this experience. I have not regarded Sir not just as a senior in the profession, but as a mentor, someone whose discipline, clarity of thought, and unwavering commitment to ethics have left a lasting impression on my own approach to the practice of law. Today, as Sir shares his reflections on his journey and his vision for the road ahead, I have no doubt that all of us will carry not only insights into litigation as a career, but also inspiration on what it means to practice law with responsibility and integrity. So, therefore, without further ado, on behalf of everyone gathered here, and particularly on behalf of the management, sir, it is my privilege to extend a very warm welcome to sir and invite him to deliver this special address. Thank you. Sir, you may please commence.
I have to start now?
Yes, sir.
Okay. See, I am really grateful to the management and the administrative setup of the Guru Kashi University, Bathinda, Pilwandi Sabu, for giving me an opportunity to interact with the students, teachers, and all other connected with the legal fraternity on 2-3 issues. I am really grateful to them, and I like to make my small submissions within 15-20 minutes, and then I'll go for question answer session, because that is also one of the most important features of any interaction, any webinar, seminar, or whatever it is. There are certain doubts sometimes in the minds of the people who are listening. It should not be a one-way traffic. So after that, I'll request all of you that in case you want to ask any question, you can put me that question. After 15-20 minutes, I have finished my job. See, 1947 में जब हमारा देश आजाद हुआ, तो उससे पहले अंग्रेजों ने हमारे यहाँ बहुत लंबे अरसे तक राज किया। तानाशाही में और लोकतंत्र में अंतर ये होता है कि तानाशाही में जो तानाशाह कहे वही कानून है, और लोकतंत्र जो है वो कानून के अनुसार चलता है। तो 1947 में देश आजाद होने के बाद हमारे सारे नेशन ने, बी द पीपल ऑफ इंडिया मीन्स द एंटायर नेशन थ्रू देयर रिप्रेजेंटेटिव्स, हमने अपने आप को एक कॉन्स्टिट्यूशन दिया। उस कॉन्स्टिट्यूशन में डेमोक्रेटिक वर्किंग, पार्टिसिपेटिव डेमोक्रेसी, डेमोक्रेटिक गवर्नमेंट इलेक्टेड बाय द पीपल, उसको अधिकार दिया कि आप कंट्री के अफेयर्स मैनेज करेंगे। और ये सिस्टम ठीक से चले तो इसके 3 पिलर बनाए। पहला, द लेजिस्लेचर टोटली इलेक्टेड बाय द पीपल ऑफ इंडिया, द एग्जीक्यूटिव ultimately indirectly or directly elected by the people of India, and the judiciary to ensure the rule of law in the country and to uphold the constitution. तीनों को अपने अपने फील्ड में सुपरमेसी दी। जुडिशरी अपने फील्ड में सुप्रीम है, लेजिस्लेचर अपने फील्ड में सुप्रीम है, एग्जीक्यूटिव अपने फील्ड में सुप्रीम है, लेकिन अल्टीमेटली जो सुपरमेसी दी वो हमने कॉन्स्टिट्यूशन ऑफ इंडिया को दी। तो अगर मैं दूसरे ढंग से कहूं कि हिंदुस्तान में कौन सरकार बनाएगा, how the government will be formed is to be decided by the people of India. Today one party is in power, tomorrow any other party can come. Day before yesterday some other party was there. But how the government is to be run, सरकार कौन बनाएगा ये लोग तय करेंगे, पर सरकार कैसे चलेगी ये हिंदुस्तान के कॉन्स्टिट्यूशन के मुताबिक चलेगा। इसलिए हमारे मुल्क में रूल ऑफ लॉ बना, नागरिक को फंडामेंटल राइट्स दिए गए, बहुत लंबा चौड़ा कॉन्स्टिट्यूशन बना, मैं उसमें जाना नहीं चाह रहा। आज लिटिगेशन की जो स्थिति है उसमें जजेस, लॉयर, लिटिगेंट, ये 3 बहुत इंपॉर्टेंट एस्पेक्ट है। सबसे पहले लिटिगेंट आता है, जिसका कोई डिस्प्यूट है सरकार के साथ, आपस में पर्सनल प्राइवेट। दूसरा बेसिकली जो ये जिनका झगड़ा है या जिनका लिटिगेशन है, और जुडिशरी जिसने निर्णय करना है, जिसने डिसाइड करना अल्टीमेटली कौन ठीक है कौन गलत है, कौन सा पक्ष सही है कौन सा नहीं। और उसके बीच में जो दूसरी कैटेगरी आती है जो सबसे महत्वपूर्ण है वो है लॉयर्स की, जिसने असिस्ट करना है जजेस को टू कम टू ए राइट कंक्लूजन। आज तक दुनिया में जस्टिस शब्द की परिभाषा को डेफिनेट नहीं दे पाया है कि क्या जस्टिस है ये डिपेंड करता है पर्टिकुलर सिचुएशन पे, फैक्ट्स पे, उस समय कैसे प्लीड हुआ। लेकिन उसकी सबसे महत्वपूर्ण कड़ी क्लाइंट जज के बीच में लॉयर, और लॉयर भी आगे दो कैटेगरी में चले जाते हैं। पहली कैटेगरी जो पटिशनर्स नॉर्मल एवरेज पटिशनर हैं, जिनका कोई पर्सनल डिस्प्यूट है, जिसका कोई पर्सनल कॉज ऑफ एक्शन है, ऑर्डिनरली कॉल्ड एज द पटिशनर्स लॉयर्स। और सेकंड कैटेगरी आ जाती है those who are defending the institution, the system. We the people of India mean the Union of India, and the Union of India is represented, or the state of Punjab or any other institution, by a particular set of lawyers. आज का जो आपका टॉपिक है, litigation career as counsel for the Union of India, responsibilities, reflections and the road ahead. मैं समझता हूं कि आपका जो गवर्नमेंट साइड से एक्सपीरियंस है, आपकी जो रिस्पॉन्सिबिलिटीज हैं, वो बाकी पटिशनर से भी कहीं ज्यादा होती है। क्यों होती है? क्योंकि आप जिस सिस्टम को रिप्रेजेंट कर रहे हो, उस सिस्टम को समझने के लिए डीप जाना बहुत आवश्यक है। पटिशनर साइड कई बार उस चीज को समझ नहीं पाता। मैं आपको एग्जांपल देना चाहता हूं। अभी हाईकोर्ट में, पंजाब हरियाणा हाईकोर्ट का होलिस्टिक डेवलपमेंट प्लान का एक्सपेंशन का इशू चल रहा है। एक प्लान बना, प्लान बनने के बाद वो एग्जीक्यूशन के लिए आया, उसकी प्रॉब्लम्स आई, यूनेस्को में गया, वर्ल्ड हेरिटेज कमेटी ने प्रॉब्लम की। आप किसी नॉर्मल आदमी से करें, उसको लगता है क्या दिक्कत है, कर दीजिए, नई बिल्डिंग बनेगी, नया स्ट्रक्चर बनेगा। बट दोज हु आर रिप्रेजेंटिंग द यूनियन, रिप्रेजेंटिंग द स्टेट, they know their own problems, they know their own difficulties that they are facing. And here is the job of a government lawyer, the maybe state, maybe Union of India, to first understand the whole situation, whole issue, the issue involved, then understand the complications, implications and problems of the union or the state which you are representing. And the third comes when you have to ultimately reconcile between the two, assist the bench, saying that this is the right course of action. Your action depends, it will ultimately determine the prestige of the institution. Ordinarily, your client is standing on your head. जिसकी प्रमोशन नहीं हुई, जिसका लेने देने का झगड़ा है, जिसका मकान का झगड़ा है, किराएदार का झगड़ा है, स्टेट के जो लॉयर्स हैं, उनका क्लाइंट उनके हेड पे नहीं होता है। He has to behave like a state. He has to behave like the union, because the whole reputation of the state or the union depends upon your conduct, on your behavior. So therefore, any lawyer, maybe for the private side also, at the government side also, they should be fully prepared on the facts of the case. I am again repeating, a lawyer must be very clear on the facts of the case. Unless you are clear on the facts of the case, you cannot do justice. And sometimes a small variation in a particular fact changes the whole complexion of the problem. A lawyer should always be awake, alert, awakened. जानकारी होनी चाहिए दुनिया में क्या हो रहा है, क्या इशू है, क्या इन्वॉल्व है. Assertive and need be aggressive also. Needs be aggressive also, because your attitude, your behavior will be reflected in the judgment. And if you are not able to assist the judges properly, if you are not able to give the total background of the case from the government's point of view, it can create many complications. We have seen in law sometimes a judgment, because of the non-preparation of the lawyer, because of many other factors, can lead to a judgment which can create havoc in the country, in the system. So the responsibility of a Union of India lawyer is much more than the lawyer on the other side. Though approach of the both should be the same. Both have to be we are fortunate to have in our country a judiciary which is primarily independent. Over the years, 70, 80 years, the judiciary has stood the test of independence. Judiciary has to be independent. We have to defend the rule of law. Judiciary has to uphold the rule of law. And judiciary has proven by its conduct, assisted by the lawyers from both the sides, that on certain occasion, they can rise above all these small considerations. And I have been giving two examples to the all people involved. It is only in the whole world, in India, that a judge, single judge of the Allahabad High Court, who had come by promotion from the session judge to the High Court, that too for a very short period, he set aside the election of the sitting Prime Minister of India. In the entire world, there is no example of any single judge setting aside the election of the Prime Minister of any other country. It is only in our country, proving the independence of the judiciary as well as the assistance of the lawyers who assisted that honorable judge from the all angles so that he could arrive at a particular decision. And the second example which I am giving is the National Judicial Appointment Commission Act. This act was enacted by the Parliament of India unanimously. Very rare in Indian parliamentary democracy. All parties, BJP, Congress, Akali Dal, all parties put together, they unanimously drafted and passed that bill. The executive performed its function. It goes for scrutiny to the judiciary. A 5 judges bench is constituted. 5 judges bench with the ratio of 4-1 says no, it is against the basic structure of the Constitution of India. They strike down that act. Whether it is what is basic structure or not is not the topic for today's discussion. I am not entering into that. But what I am saying is this, that we the lawyers should be proud of it, that our judiciary, our system is so independent that they can give a judgment against the sitting Prime Minister also, and they can go against the unanimous decision of the Parliament also. Very rare in the entire democracy, in the all countries and all over the world. It is this system in which we are working, and our responsibilities. What are the responsibilities? Judge will decide a case on the basis of the facts and evidence brought on his court. I expect from my government lawyers, you, with a view to strengthen the democracy, with a view to strengthen the judiciary, with a view to assist the judiciary, first should be fully prepared with your case. Call the officer, call the files, see for yourself. Because sometimes an officer sitting in the office may not be having that vision, may not be having that perspective which a lawyer will be having. Call him, discuss with him, be clear on your facts. Law even the judges know, law even the other side know, but your facts only you can know. And first be clear about the facts. And the second thing which I have been saying, what is the basic requirement for being a successful lawyer? Only 2 things apart from other things. Number 1, जो दूसरे की बात को समझ सके, मीनिंग देयर बाय आपके पास क्लाइंट आया, आपके पास ऑफिसर आया, आप समझ सके कि वो क्या कहना चाहता है, वो कैपेसिटी आप में होनी चाहिए, और दूसरी अपनी बात दूसरी जगह समझा सके, फिर आपको वो बात के बाद आपको जज को कन्विंस करना है. अगर ये 2 क्वालिटीज आपके अंदर आती हैं तो आप सक्सेसफुल लॉयर हैं, चाहे गवर्नमेंट की तरफ से है, चाहे आप प्राइवेट साइड में अपीयर हो. और मैंने देखा है अपने एक्सपीरियंस से बहुत सारे केसेस में, कई बार आपका पर्सपेक्टिव, आपका विजन, आपका आइडिया टोटल डिफरेंट होता है, लेकिन जब आप फैक्ट्स देखते हो, फाइल देखते हो, उसमें स्टडी करते हो, तो आपको 4 चीजें नई भी मिलती हैं. और जहां कहीं कोई आपको ऑफिसर अपने कुछ गलत चीजें छिपाने के लिए मिसलीड करने की कोशिश करता है, आप उसमें भी जाते हैं. तो सबसे पहली बात, फर्स्ट बी क्लियर ऑन फैक्ट्स, सी द फैक्ट्स फॉर योरसेल्फ. खुद फाइल देखिए, खुद नोटिंग देखिए. नंबर 2, द प्रिपरेशन ऑफ द काउंटर एफिडेविट, रिटन स्टेटमेंट और इवन व्हाटएवर इट इज यू मे कॉल, उसकी लैंग्वेज पोलाइट होनी चाहिए, फर्म होनी चाहिए, सबमिसिव होनी चाहिए, ऑफेंसिव नहीं होनी चाहिए. वही बात आप बड़े प्यार से भी कह सकते हैं. आपकी ड्राफ्टिंग में लैंग्वेज पे कमांड रिफ्लेक्ट होनी चाहिए, ग्रेसफुल होनी चाहिए, फैक्ट्स पे बेस होनी चाहिए. कभी मत सोचिए कि भी अगर मैंने ये बात कह दी तो केस मेरे खिलाफ चला जाएगा, ये बात मैंने ना कही तो मेरे को ये हो जाएगा. So far as the facts are clear, don't play with the facts. Let facts remain the facts. Don't enter into those things. Facts should be clear. हाँ, क्या वहां की रिक्वायरमेंट है, कितना आपने स्टेट करना है, कितनी वहां की वक्त है, वो देखने वाली डिपेंड करता है. थर्ड, द लॉ. किसी आदमी ने मेरे को, जब मैंने अभी प्रैक्टिस शुरू नहीं की तब कहा था कि आपने कोई एक्ट, कोई रूल, कोई लॉ चाहे कितनी मर्जी बार पढ़ा हो, लेकिन जब आप उसको साइट करने लगे हो, एक बार दोबारा देखिए, एक बार उसको दोबारा पढ़िए, और उस पर्सपेक्टिव में उसी लॉ को, उसी जजमेंट को जब आप एक बार दोबारा देखते हैं, जब एक बार दोबारा आप पढ़ते हैं, तो आपको बहुत सारी चीजें क्लियर उसमें से निकलती हैं. आपको खुद लगता है कि अच्छा यार, ये एंगल तो मैंने देखा ही नहीं, ये तो मेरे ध्यान में ही नहीं. डू दैट ऑल्सो. That will ultimately help you in coming out to be one of the best lawyers. जस्टिस मैंने कहा जो यूनियन ऑफ इंडिया या स्टेट के लॉयर्स हैं उनका जॉब बड़ा टफ होता है क्योंकि सबसे बड़ी लिटिगेंट स्टेट है, यूनियन ऑफ इंडिया है, इंस्टीट्यूशंस है और उन्हीं के एक्शन चैलेंज किए होते हैं। आपको जहां अपने क्लाइंट का इंटरेस्ट वॉच करना है क्योंकि आप यूनियन को रिप्रेजेंट करते हैं, आप स्टेट को रिप्रेजेंट करते हैं, वहीं आपका इस बात का भी आपको ध्यान रखना है कि आपके जो सिटीजन्स हैं उनके साथ जस्टिस भी होना चाहिए, उनके साथ बेइंसाफी नहीं होनी चाहिए। लेकिन इसको कैसे अचीव करना, मैंने कहा आप अगर ऑफिसर्स को बुलाते हैं, उनको कॉल करते हैं और आप उनसे डिस्कस करते हैं, तो जहां हमें लगे कि ये पेटेंटली इलीगल है, इसके अंदर ज्यादती हो रही है, इट्स आवर ड्यूटी टू ब्रिंग इट टू दैट नोटिस टू ऑफ दैट ऑफिसर. Don't allow the officer to play with the law. Don't allow the concerned department to play with the facts of the case. A lawyer owes a duty to both, to the client also as well as to the court also, and third, above all, to the system of justice, administration of justice. That is also our prime responsibility. और मैं समझता हूं कि हम अगर इन चीजों पर चलते हैं तो आगे दौर के अंदर आकर हमको इजी रहेगा और अपनी जॉब हम पूरी कर पाएंगे। देखिए, केस में किसी ने कहा ना कि आप केस भले ही लूज कर दें बट नेवर लूज द जज। क्या मतलब? मतलब ये है कि आप अपने केस के अंदर जीतने के लिए जो अनएथिकल हथकंडे हैं उसको कभी मत बनाएं। लॉन्ग रन में कभी ये पे नहीं करता। आप एक बार किसी जज को कोई बात झूठ बोलकर, छुपाकर, हो सकता है उस समय केस लेने में कामयाब हो जाए, जीतने में कामयाब हो जाए, लेकिन जब वो चीज बाहर आती है तो आपकी क्रेडिबिलिटी स्ट्रॉन्ग। किसी ने कहा कि नेवर, यू मे लूज द केस बट नेवर लूज योर क्रेडिबिलिटी। बी फेयर, बी स्ट्रेट फॉरवर्ड, बी वेरी स्पेसिफिक, टू द पॉइंट। इधर उधर की कहानी डालने से कुछ निकलता नहीं है। मेरे को 45 साल हो गए प्रोफेशन में। मैं लगभग 35 इयर्स पिटिशनर साइड से पेश होता रहा, अभी 10-11 साल से यूनियन ऑफ इंडिया की तरफ से पेश हो रहा हूं, और दोनों तरफ से एक्सपीरियंस होने के बाद ये निकला है कि जिंदगी में अल्टीमेटली सिंसियरिटी और कमिटमेंट पे करती है। प्राइवेट क्लाइंट तो आपके सर पे खड़ा होता है, सुबह आ जाता है, बाबूजी हमारे केस का क्या होगा, आपने फाइल किया नहीं किया, स्टडी किया नहीं किया। लेकिन जो सरकारी लॉयर्स हैं, क्लाइंट उनके सर पर जरूरी नहीं कि खड़ा हो, उसको तो शायद वो अपना एफिडेविट भेजने के बाद अपने काम में व्यस्त है। उस समय आप ये प्रिज्यूम करके चलिए, ट्रू टू योर जॉब, दैट यू आर द गवर्नमेंट ऑफ इंडिया, इट इज यू हु हैव टू डिफेंड द गवर्नमेंट ऑफ इंडिया। द फ्यूचर, द इंटरेस्ट and the prestige of the government of India depends upon your hard work, your preparation, and your delivery before the judge. Any slackness on your part can create havoc with you. I remember in the court of Justice Rajiv Sharma, a few years back, some criminal appeal was going on. He requested for the lawyer to come. Somebody said कि नहीं, lawyer यहाँ नहीं। Anyhow, उन्होंने केस पढ़ना शुरू किया, आधे घंटे के बाद वो लॉयर आया। तो जस्टिस राजीव शर्मा ने ओपन कोर्ट में कहा, उसने कहा देखिए, मैं एक बात आपसे कहना चाहता हूं, ये सज्जन 20 साल की सजा हुई है इनको, इनकी क्रिमिनल अपील यहां लगी हुई है आज, और कई साल से ये अपील पेंडिंग है। मैंने बुलाया, आप आए नहीं, आप लेट आए, मुझे मालूम था कि आप आएंगे जब मैं फाइल करना शुरू कर दूंगा। तो उसने कहा देखिए, छोटी सी हमारी मिस्टेक या आपकी मिस्टेक इस आदमी को जिंदगी भर जेल में भेज सकती है, इसकी सारे जीवन जेल में बिताना पड़ सकता है, कितने साल की सजा हो जाए, कितना फाइन हो जाए। अगर हम अपना जॉब पूरा नहीं करते, अगर हमारे पार्ट पे लापरवाही होती है, तो उसका नुकसान तो इसको भुगतना पड़ेगा। किसी ने ठीक कहा, डॉक्टर और लॉयर दोनों की मिस्टेक, दोनों की नेग्लिजेंस, दोनों की लापरवाही का जो विक्टिम है वो स्वयं नहीं है, वो थर्ड आदमी है जिसको हम रिप्रेजेंट कर रहे हैं, जिसको हम ट्रीट कर रहे हैं। तो मेरी आपसे सबसे यही रिक्वेस्ट है, आप अपने केसेस में, प्रोफेशन में सिंसियरिटी से काम करें, कमिटमेंट से काम करें, और किसी किस्म की स्लैकनेस कभी मत आने दीजिए, कभी मत आने दीजिएगा। और मैं तो इतना ही कहना चाहता हूं, आखिर में अपनी बात समाप्त करूंगा। हिंदुस्तान के कॉन्स्टिट्यूशन में हम लोगों ने पढ़े हैं फंडामेंटल राइट्स। ये 10वीं जमात से नागरिक के मौलिक अधिकार हमने पढ़ने शुरू कर दिए थे, जो आज तक भी पढ़ा रहे हैं यूनिवर्सिटी में, कॉलेजेस में। रिट पिटिशंस आती हैं एनफोर्सिंग आर्टिकल 14, 21, 20 व्हाटएवर इट इज। बट ड्यूरिंग द इमरजेंसी 75-76, when as a student leader I was in jail opposing the emergency, that apart I am not touching that issue today. An amendment was made in the Constitution of India by which Article 51A of the Constitution was introduced in the Constitution of India. What is this article? Though it falls in the directive principles of the state policy, it's not enforceable in the court of law. It enshrines the basic duties of a citizen of India. Article 14, etc., that chapter deals with the fundamental rights. This chapter deals with the fundamental duties. There are 11 duties of each and every citizen. The Constitution, the system expects us to perform our duties. They only expect from us because it can't be enforced in a court of law. Nobody can file a writ and say, ask him to do his duty, ask him to perform their duty. But one of the duties which is applicable to all, which we have not to teach to others, but we have to follow ourselves. And that fundamental duty is to strive for achieving excellence in all walks of life. जीवन के जिस भी क्षेत्र में है उसमें सर्वोच्च स्थान पर पहुंचने का प्रयास करना ये आज भारत के हर नागरिक की जिम्मेवारी है. ये अमेंडमेंट हुई थी, हालांकि एक अमेंडमेंट जिसका काफी डिस्प्यूट कभी कभी आ जाता है कि भी 75 में why the words socialist and secular were introduced in the preamble of the Constitution of India. I will not touch that issue today, but just I will say only one thing, that those who are opposing it, they don't say that India should not be a secular country or a socialist country. What we are saying was, those who are opposing it say that no, there is no need of mentioning these two words because it is the ethos of India that we are secular and we are secular and socialist. From the very beginning, there's no need of adding these words. But anyhow, that is not the issue of today's debate. So this article was introduced. So it is the duty of every citizen, you also, me also, judges also, lawyers also, to strive for achieving excellence on all walks of life. What does it mean? If you're a housewife, be a good housewife. You are a student, be a good student. You are a peon, be a best peon. You are a judge, become the best judge. You are an officer, become the best officer. You are a farmer, try to become the best farmer. So to strive for achieving excellence in all walks of life means wherever we are, strive for going to the top of the world, strive for achieving excellence in that walk of life. And if we all try and work with zeal in that direction, I'm confident collectively we will be able to take our nation forward. And as our Prime Minister Narendra Modi ji says that now this century, Swami Vivekananda said, this century will be the century of India. And our Prime Minister says that in coming years, let's become the country which is the top of the world, number one in the entire world. And in that case, we have to ensure justice to all our citizens, as has been mentioned in the Constitution preamble also. And for doing that, for ensuring justice, we have to perform our job with sincerity, commitment, and all. Thank you very much. If anybody wants any clarification, it will be.
थैंक यू सर. आज आपने जो आपके जो वर्ड्स थे ये बच्चों को जरूर मोटिवेट करेंगे. एंड आज आपने जो बताया कि कैसे एक अच्छा एडवोकेट
हेलो हेलो सर आ रहा जी चमकौर साइड में पड़ के जांदी जी
कि कैसे एक अच्छा एक स्टूडेंट एक अच्छा एडवोकेट बन सकता है, कैसे वो वे में प्रैक्टिस कर सकता है. तो ये जो हमारे आने वाली जनरेशन है उसके लिए कितना जरूरी है. सर, नाउ आई वांट टू ओपन this for the question answer session. All the participants, I will allow you, and if you have any kind of question, you can interact one by one. I request the participants to please interact with the Honorable Jain sir.
Good morning, Jain sir. Sir, Alankrit Bhardat this side. Sir, I just want to from your wisdom, I just want to ask a little question that many times we see the judge is biased towards the government councils and towards the authorities, and he is already holding a kind of presumption and assumptions against the departments. So in such a situation, how to deal the case before that judge? Because it is very difficult to defend the case from the union side before such a judge who is already biased towards the departments. Kindly enlighten us.
देखिए, the constitution, the system expects every judge to be objective and open to conviction till he finally passes the order. That is the expectation from a judge, and I hope every judge ordinarily follows that procedure. You look it from another angle also. Why did that honorable judge form that opinion? This means that on certain occasions, you or the lawyers representing government may not be able to bring all the facts, all the laws to the notice of the honorable judge. He might have felt offended because of our failure to assist him properly. Sometimes, see, you feel that you are doing the best, but the judge feels something more is wanted from you. Ultimately, decision is in the hands of the judge. It is he who has to be convinced. And if we are not able to convince him, I think there is, let's examine from our point of view also and try to introspect and find out, is there something wanting on my part also? Is there something which was more to be done which I have not been able to do? Is there was something expectation of the honorable judge from me which I have not been able to do? Ultimately, Hani Labh Jivan Maran Yash Apyash Vidhiha. Ultimately, all depends upon the luck of the client and the situation. But I will request, let's take it from the other point of view also. Let's try to improve our working. Do whatever you can do. So far as your conscience is concerned, our conscience should be satisfied that I have done whatever was required. I have done whatever was expected from me. And from that point of view, there was no slackness on my part. There was no attempt to mislead the honorable court, no attempt to conceal anything from the court. Ultimately, it is the honorable judge who has to pass the final order. And never think that with all respect to the judiciary, that judge is final. I remember a case, Mr. Bhagwant Singh Sidhu. He was the Advocate General of Punjab. Somewhere 80s when Sardar Dabbar Singh was the Chief Minister. I had joined the profession in January 80. He was arguing a case before the full bench, consisting of Justice P.C. Jain, Justice Tavatia, and Justice Kang, perhaps, maybe some other things. He made some submission. So the Honorable Judge said, no, Mr. Sidhu, this is not the correct proposition of law. He closed his file. He used to speak very slowly. He says, Your Lordship, don't say that I am not correct. Don't say that you are correct. Usne kaha, today, you are the judges, I am the lawyer. So whatever you say will prevail as law. But tell me, suppose your judgment is overruled by the Supreme Court, and who will be right and who will be wrong? And he further said that who knows, after 10 years, Supreme Court may overrule its own judgment, saying no, that was not correctly decided. So judicial process, it continues. It's an evolving process. What law will prevail at a particular time will be decided by that time. Yeah, we daily see in the courts a judgment, the appointment of certain assistant professors in the state of Punjab. High Court had dismissed that petition. About 1,100 teachers. The matter went to Supreme Court. Supreme Court set aside the judgment of the DB. Later on, they have stayed the judgment for a few days. So law is a evolving process. You cannot say that this is the final word on the judicial history. It is evolving. Today, something may be legal. Tomorrow, it may not be legal. So therefore, give proper assistance to the judge. If there is something is wanting, go to an appeal to the division bench, full bench, High Court, Supreme Court, anywhere. Don't lose heart. Don't lose heart. Be brave. Continue fighting. Karta karta abhyas te janmati hot sujan. Lage rahiye.
So thank you so much, sir.
Any other question? Any student?
I request the participant, it's a one-time opportunity to interact with Honorable Satya Pal Jain ji face to face.
Hello.
You will miss this opportunity. Yes, please.
Hello. Good morning, sir.
Good morning.
Sir,
Yes, Mr. Amarinder Singh. Yes.
yes, sir. Sir, my question is, given the increasing the workload and backlog of the cases in the court, what reforms and strategies do you think they are needed to improve the efficiency in the government litigation?
See, there are two aspects of this problem. One is increasing workload is everywhere, right from civil judge to Supreme Court. In the entire country, as per my information, more than 3 crores cases are pending. And the worst affected is the lower judiciary, which never comes to the limelight. So far as the judicial reforms are concerned, from this point of view, there are 3 things which need to be done. Number one, there is a need to increase the number of judges. Civil trial court also, high court also, Supreme Court also. That is one. Second is the attempt on the part of the judges also to dispose of the cases as much they can. And in that matter, basically, it is the equally responsibility of the lawyers also. We see in the courts, I'm not blaming any lawyer for that particular person. I may not be misunderstood, but it has been noticed that sometimes the lawyers also do not wish, because of certain reasons or because of certain problem, to decide the cases as early as possible. If you have got those parties who get stay, they try to delay because there is a stay in their favor. Those who have not got it, they say all right, अब stay तो मिला नहीं, देखा जाएगा जो होगा, काय को जल्दी करनी है. Anyhow, third thing which you are saying is very relevant and now which is attracting the attention of all the governments. I have been also writing to the government of India from time to time. See, the government of India and the state governments, government of India has now framed a litigation policy. States are also framing it. Certain cases can be avoided from coming to the courts if you follow that litigation policy. For example, now the government of India has said no department of the government of India will go against the another department of the government of India to the court of law. If there is a dispute between two ministries, if there is a dispute between two departments, go to the cabinet secretary, take the internal mechanism and try to sort out that issue within the framework of the government of India. Earlier we have been finding power ministry fighting against the finance ministry, the legal ministry going against particular another ministry. Many examples can be given. So this, number one, do not try to reduce the litigation. Number two, when a judgment comes on a particular point of view, it comes, it has become finally, it has attained finality up to Supreme Court. Then why should not that be followed in all other cases also? Why should we compel other people who are covered by that judgment to come to the court of law and get those interim orders? That should also be avoided. Third, the filing of the appeals. You must have read in the newspapers a few days back, sometimes Supreme Court, sometimes High Court. They have been imposing heavy cost on the state governments or on the central government or other institution. There is nothing in this case. The dispute is for the recovery of a few thousand, 10,000, 15,000 from an employee who is retired, and you're spending lakhs and lakhs of money in engaging lawyers going up to Supreme Court. What for? What for? So I think the litigation policy of all the states should be revised in consultation with each other, involving the judiciary also, involving the lawyers also. I remember somebody told me, I am not aware of it, that during British rule, there used to be regular meetings between the session judge, the deputy commissioner, who was the district magistrate, and few legal people, the police also, who is the basic, very important prosecuting authority, to sort out the issues so that in their coordination meeting they come to know of it. What are the problems that the police is facing? What are the problems that the lawyers are facing? And the judiciary, what does the judiciary feel about those matters? There used to be regular meeting between them. I think such type of mechanism should be evolved.
Thank you, sir.
Yes, please. Any other questions?
Yes, sir.
Yes, please.
Mr. Hassanpreet Singh.
Yes, sir. Good morning,
Bolo,
sir.
bolo.
Sir, do you think that a higher judiciary of our country should be independent without any political interference, as we know that the judges of our judges of our higher courts are selected on the basis of the reference of the bar councils, associations, bodies? Can the selection be on the exam merit basis?
See, this issue has two aspects and two dimensions. First, the present system, the judges of the High Court, and the Supreme Court are selected by the collegium and then ultimately notified by the government. So far as the district judiciary is concerned, sub-judge, ADJ, DJ, etc., there the same pattern is followed which you are suggesting. And now a judgment has come that if you want to appear in the civil service exam, you must have 3 years as practice, which is some are welcoming it and some are criticizing it. But anyhow, that system is followed there. For the High Court and Supreme Court, it is wrong to suggest that the judges are appointed on the political reference. How do the judges are appointed? First, the collegium of the High Court, 3-5 senior most judges, they sit together, they suggest certain names for elevation as judges. In the Supreme Court, when the vacancy arises, the senior most 5 judges of the Supreme Court sit together and they find out as to who should be elevated to the Supreme Court. The High Court recommendation again goes to the Supreme Court collegium. They again meet, they discuss, and then the Government of India, on the other hand, gets the IB report about the functioning, about the secret information, about their all other things, which is also placed before the collegium. Then the collegium makes its recommendation. It comes to the government examines it. If there is any clarification, any modification, then the matter is again sent back to the Supreme Court collegium. They again examine and send it back. Judges are not appointed on political consideration, and I totally agree with you. No judge should be appointed. Judges should not at all be appointed on political consideration. Rather, judges should be above political consideration. And I think, I don't know whether you joined when I opened my discussion or you not. I gave 2 examples of the independence of the judiciary, which is not available in the entire world. Number 1, the election of the Prime Minister was set aside by a single judge of the Allahabad High Court. Do you find this example in any other part of the country, of the world? Second, the second solution to your problem was the National Judicial Appointment Commission. The Parliament thought, let's go away with the collegium and all that. Let's constitute a National Judicial Appointment Commission consisting of Chief Justice, senior most judges, legal luminaries, law minister to select the judges through any process that may deem fit. The Supreme Court constituted a 5 judges bench, constitutional bench, and it 4-1. 4 judges said it is against the constitution. 1 said no, it is not against the constitution. By majority, it was struck down. So see, what more proof do we require about the independence of the judiciary? Simply because judge is not deciding the case as I want him to be decided. It doesn't mean that they are not independent. By and large, Indian judiciary has said, हाँ, कहीं-कहीं जैसे अभी ये वर्मा का केस आया दिल्ली में, जिनके घर से नोटों की वो सारा मामला अभी पार्लियामेंट में चल रहा है, सुप्रीम कोर्ट में चल रहा है. कहीं-कहीं जिसे हम अपनी साधारण पंजाबी भाषा में काली भेड़ बोलते हैं, वो कहीं-कहीं आ जाती है, वो हर जगह आ जाती है. वो रामायण के टाइम में भी मंत्रा के कई आ गई थी, वो महाभारत में भी आ गई थी. वो कहीं-कहीं आ जाती है, लेकिन by and large Indian judiciary is independent. It's performing its job very well.
Thank you, sir.
Yes, please.
Good morning, sir. So I had a question.
Karan, हाँ बोलो.
So what is one advice, sir, you would like to give to any government council, sir, whether a state government council or central government council, on how to be a better government council or how to perform efficiently or better as a government council, sir?
पहले सारा केस समझो, फिर पटिशन को ध्यान से पढ़ो, अपने गवर्नमेंट लॉयर को, गवर्नमेंट के ऑफिशियल्स को बुलाइए, स्टडी करिए. स्टडी करने के बाद क्लियर हो जाइए कि इस केस में क्या प्लस है, क्या नेगेटिव, और फिर कीपिंग इन व्यू द जस्टिस एडवाइस द जजेस. मैं आपको बता रहा हूँ, लॉयर मैंने 80 में ज्वाइन किया था. 1-2 साल के बाद एक बार मैं केस आर्ग्यू करके निकला, तो जस्टिस जीसी मित्तल जो आज इस दुनिया में नहीं है, उनके पीएन मुझे बुलाने आए. मुझे डर लगा कि पता नहीं क्या बात है, मेरे से क्या गलती हो गई. तो उन्होंने बुलाया, मैं चैम्बर में गया. मैंने कहा सर, मैं खड़ा था, कहते बैठिए. मैंने कहा सर बताइए. कहते नहीं नहीं, कोई घबराने वाली बात नहीं है. मैंने तुमसे ये पूछा कि तुम अपना केस कैसे तैयार करते हो. उन दिनों सिविल अपील रिविजनें ज्यादा होती थी, रिटें कम होती थी. तो मैंने कहा जी जजमेंट आती है, हम जजमेंट पढ़ते हैं, हम देखते हैं, हम करते हैं वो. तो उन्होंने कहा कि नहीं, ऐसे मत करिए. तो मैंने कहा जी फिर कैसे करूं, मुझे बताइए. तो उन्होंने कहा देखिए, आपके पास जब कोई सिविल अपील आती है, रिविजन आती है, सबसे पहले आप दावा पढ़िए, प्लेंट, चाहे वो आपके क्लाइंट ने डाला था, चाहे दूसरे ने डाला. फिर आप रिटर्न स्टेटमेंट पढ़िए, फिर उसके बाद एविडेंस पढ़िए. और द पॉइंट ही से एट दैट टाइम व्हिच इज रेलेवेंट इवन टुडे, he says after reading all this, you make up your mind that suppose you are a judge and this case is before you, how will you decide this case? And once you make up your mind, then you read the judgment. He says within hour you will be able to find out whether the judge is right or judge is wrong. So if we evolve that process, understand the whole thing, understand the facts of the case, then the law on that point, and then call the officer. And if the officer is wrong, convey him that no, you are violating law. I'm there to defend the government and the institution. Please follow the law.
Sir,
Thank you, sir. Thank you for your wisdom.
Sir, there are some questions in the chat box.
बताइए, मुझे पढ़ दीजिए.
Yes, sir. What common mistakes do young advocates make in the beginning of their practices, and how can they avoid them?
देखिए, सबसे पहली बात यह है, आप क्लाइंट मत बनिए, लॉयर रहिए. केस में इमोशनल अटैचमेंट मत करिए. मैंने जो कहा वही बात सब पे मैं बार बार फीड करता हूं. फैक्ट्स पे क्लियर रहिए, मेहनत करिए और अपनी बात कहिए. लॉयर कौन है कामयाब? जो दूसरे की समझ सके, अपनी समझा सके. तो पहले केस को समझिए, फिर अपने पॉइंट ऑफ व्यू को जज को समझाइए. निर्णय जज पे छोड़ दीजिए. जो गुरु वशिष्ठ ने बहुत देर पहले कहा था ना, सुन रे भरत भावी प्रबल कहे मुनिनाथ, हानि लाभ जीवन मरण यश अपयश विद्या, वो अपने हाथ में नहीं है. और गौराणी में कहा कि जो मन चित्त न चेते सन सो गाली रब किए, वो लीगल प्रोफेशन में भी होता है. तो अपनी बात कहिए. लॉयर मैंने देखा है, मैं अब तक हिंदुस्तान की 25 हाईकोर्ट में से 18 हाईकोर्ट में जा चुका हूं. सिक्किम, बंगलौर, गोवा, सेंट्रल इंडिया के तो लगभग सारे के सारे. और मैं देख रहा हूं पिछले 8-10 साल से जो नई जनरेशन आ रही है, जो नए लॉयर्स आ रहे हैं, दे आर डूइंग वेरी वेल. और आज तो टेक्नोलॉजी की एडवांसमेंट इतनी आ गई है. हम स्कूलों में जाते थे ना, तो हमारे पास स्लेट होती थी जिसपे वो लिखा करते थे. अब तो वो सिस्टम बंद हो गया. आज आपका आईफोन इतना का आ गया है, ना आपको बुक्स लगाने की जरूरत है, ना आपको पेपर बुक ले जाने की जरूरत है. वहीं बैठे बैठे आप खोल के केस को आर्ग्यू कर लेते हो. हमें याद है जब हम जगन्नाथ कौशल, हीरालाल सिब्बल, ये लॉयर्स के साथ प्रैक्टिस करते थे, केस आर्ग्यू करना है, 2 बॉक्स बैग आ गए हैं, किताबें आ रही हैं, फाइलें आ रही हैं, जजमेंट्स आ रही हैं, लिस्ट ऑफ बुक्स दे रहे हैं जज को. आज तो कुछ भी नहीं है. जज के पास भी स्क्रीन है, आपके पास भी स्क्रीन है. आप टिक टिक करके जो उसको दिखाना चाहते हैं दिखाइए. टेक्नोलॉजी की एडवांसमेंट, वहां बैठे बैठे आप टिक 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 करिए. लेटेस्ट जजमेंट अगर उसी दिन भी सुप्रीम कोर्ट ने डिलीवर की है जिस दिन आप आर्ग्यू कर रहे हो, तो वो स्क्रीन पे आपके आ जाएगी. डाउनलोड करिए, जज को पास करिए. इसलिए हार्ड वर्क करिए. मैंने जो शुरू में कहा ना, अलर्ट, अवेयर, अवेकन, असर्टिव एंड नीड बी अग्रेसिव ऑल्सो. अगर ये 5-6 फैक्टर हम अडॉप्ट करके चलते हैं, केस जीता या हारा ये कम महत्वपूर्ण का है. केस के बाहर आने के बाद आपकी आत्मा, आपका मन, आपकी कॉन्शियस आपको कहे कि सतपाल, मैंने जो करना था वो कर दिया, बाकी उसके भाग्य की बात. नेक्स्ट.
Sir, there is another question from
प्रज्वल
Roshan
वर्मा.
Kumar.
हाँ, बोलो.
जी सर. Sir, as you are representing the Union of India, it often involves high pressure situations where national interest, public policy is at stake. How do you manage the mental and emotional pressure in such cases?
देखिए, आप बिल्कुल ठीक कह रहे हैं. कई बार बहुत ऐसी सिचुएशंस आती हैं जहां बहुत टफ टाइम होता है, बहुत टफ टाइम होता है. लेकिन जो मैंने थीम जो मेरी उसका है स्पीच का, जो मैंने कहा, पहली बात तो आपके मन में क्लैरिटी होनी चाहिए. नंबर 2, आपके कंसील करना, झूठ बोलना, गलत बात करना, वो कभी मत करिए. सीधी बात जज को बताइए. जहां प्रेशर आता है, जहां कोई टेंशन आपको आती है, बहुत सारे केसेस में आती है. मैं भी आपको एक एग्जांपल देता हूं. कुछ पाकिस्तानी प्रिजनर्स हैं हमारे देश में जिनकी सजा पूरी हो गई है. उनको वापस जाना है, लेकिन वो वापस तब जाएंगे जब पाकिस्तान की गवर्नमेंट उनको ओन करेगी. उसके बिना तो वो वापस नहीं भेज सकते. ठीक है. तो मुझे याद है एक बार एक मैटर आया, तो जिसमें ऑनरेबल जज ने थोड़ा ऐसे कमेंट्स दिए जो अगर बाहर चले जाते तो गवर्नमेंट ऑफ इंडिया पे उसकी रिफ्लेक्शन हो सकती थी. ठीक. तो मैंने एकदम से ऑनरेबल जज को रिक्वेस्ट की, इवन एट द कॉस्ट ऑफ सर्टेन कॉजिंग अनॉयंस टू द जज, कि देखिए, हम आपके साथ, हम करना चाहते हैं, लेकिन प्लीज don't make any observation which can be used against the India tomorrow in the whole world. We are part of the Indian nation. We are doing our job. We are doing justice. Please don't do it. And the judges appreciate that. कई बार डिटेंशन के केस आते हैं, उसमें बहुत सारी ऐसी चीजें होती हैं जो हम सार्वजनिक नहीं कर सकते. In that situation, we give it in a sealed cover. to the judge. Judge will go through that and then take it. But ultimately, you have to manage it. But if your intention is clear, you take the judge into confidence, there will be no problem.
Thank you, sir.
Okay, is it okay?
Sir, another question
Let
from
it be
a
last
student.
because I have to go at 12 now.
Yes, sir. Sir, it's a question that what advice would you give to a student who is not from a legal background and is considering a career in litigation for the government?
देखिए, मैं खुद अपने परिवार का पहला वकील था। मेरे परिवार में मेरे से पहले कोई लॉयर नहीं था। आई वाज द फर्स्ट लॉयर। और इसलिए जो टिप्स है वो सबके लिए सेम है। आप गवर्नमेंट साइड में आए या प्राइवेट साइड में आए, हार्ड वर्क करिए, नेवर लूज हार्ट। शुरू में सबका यही हाल था, चाहे वो हरीश साल्वे हैं, चाहे वो अभिषेक मनु सिंघवी हैं, चाहे कपिल सिब्बल हैं। जब स्टार्ट किया तो सबको वही प्रॉब्लम्स आई थी। आप अपनी क्लैरिटी के साथ, कमिटमेंट के साथ चलते जाइए, भगवान आपको कामयाबी देगा। इसमें लक का भी बहुत बड़ा पार्ट होता है हमारे प्रोफेशन में, लक का भी पार्ट होता है, लेकिन डोंट लूज हार्ट। शुरू में दिक्कतें आती हैं, मुझे मालूम है लॉयर्स ऐसे भी हैं जिनकी कई बार शुरू में खर्चा भी महीने का नहीं निकलता, परिवार की किराए पे मकान लेने की प्रॉब्लम होती है, लेकिन आप ईमानदारी से लगे रहिए, मेहनत करिए। जो केस आपके पास आया है उसमें पूरी जान डालिए, पूरी ईमानदारी से काम करिए, जो लॉ सर्च करना है, जो करना वो करिए, अल्टीमेटली इट विल गिव यू रिजल्ट्स।
Good afternoon, sir.
Yes, Dr. Gurpreet Kaur.
Yes, sir. There is last question from my side. As we know, we can't
In the entire debate, you are the only girl or the lady who is putting a question. Otherwise, no. Anyhow.
Thank you so much. We can't amend basic structure of constitution. Whether there is any compromise with the sovereignty of parliament with this?
See, this is a very highly debated issue. The Supreme Court in the NC National Judicial Appointment Commission Act says it is against the basic structure of the Constitution of India. And as you know, you must have read it, in the entire Constitution from A to Z, there is this word like basic structure has not been used. Nowhere it is used. Yes. Sovereignty of the Parliament, I said, in each of the three organs, the executive, the judiciary, and the legislature, they are supreme within their own system. The legislature is free to enact any law that it wants to do it. The executive is free to implement that decision in any manner they want to do it. Judiciary is to interpret that. So ultimately, it's a system of checks and balances in the total system. No system, no part of it should try to transgress the powers of the other. One constitutional authority should respect the other constitutional authority. Making law primarily is the duty of the legislature, but judiciary has also to see that it is as per law. Not that parliament can do anything it may like, which is against the constitution. What is the basic structure of the constitution? This is an issue which is highly being debated in different forums. But the intention is that you can't take away the fundamental rights of the citizen. You remember during emergency, I was in jail because I was a student leader, general secretary of the student council, arrested because I was opposing emergency. The lawyer for the then government of India stood up in the Supreme Court and said that there is no fundamental right available to citizen now. Even the right of life and liberty is also not available. This was the argument of the lawyer for the government of India in 75 before the Supreme Court. That situation should never come. No government should be allowed to take away the fundamental rights. No government should be allowed to take away the powers of the judiciary to decide the cases. But at the same time, judiciary should also show proper respect to the legislature. So I said it's a system of checks and balances where everybody is supreme in its own field, but then again there are checks and balances in the system.
Thank you so much, sir.
Thank you, ma'am. Thank you, sir.
Thank you so much.
कोई अगर और भी है तो पूछ ले, मन में ना रह जाए कि मैंने सवाल नहीं पूछा.
Any question?
साहिल सिंह.
Yes, sir.
हाँ बोलो.
So when you look back at your journey, what was the biggest challenge you faced as a young lawyer and how did you overcome it?
See, challenges बहुत थे, कोई एक को तो बिगेस्ट कहना संभव नहीं है. हमें याद है जब मैंने प्रोफेशन ज्वाइन किया था तो इनकम नहीं बिल्कुल होती थी और कई बार और उन दिनों तो फीस 330 रुपए, 440, 550 होती थी. आज तो सुप्रीम कोर्ट के लॉयर्स 15 लाख पर अपीयरेंस पर हियरिंग लेते हैं, 20 भी लेते हैं, 11 भी लेते हैं, 5 भी लेते हैं. उस दौर में तो 550, 770, 1100 बहुत अच्छी फीस मानी जाती थी, बहुत अच्छी मानी जाती थी। लेकिन मैंने नए-नए ज्वाइन किया था, तो बहुत दिक्कत आती थी। कई बार ये भी होता था कि महीने में खर्चा कैसे निकलेगा, कैसे किराया देंगे मकान का, कैसे वो करेंगे। पर मैंने कहा कौन नानक सब तेरी वडियाई कोई नौ न जाने मेरा। परमात्मा की ग्रेस है कि आप चलते गए और मैं सबको यही कहता हूँ, घबराइए मत इस प्रोफेशन में, घबराइए मत। इनिशियल स्टेज पे सबको चैलेंजेस आते हैं, किसको नहीं आए। लेकिन अगर आप हिम्मत से चलते जाएंगे तो चाहे अपने खानदान में पहले वकील हैं, चाहे पहले भी कोई लॉयर है, और वो आप चलेंगे तो कामयाबी अंत में मिलती है। बाकी भाग्य का जो रोल है वो सब जगह है, वो बिजनेस में भी है, वो प्रैक्टिस में भी है, वो जुडिशरी में भी है, वो सब जगह है।
Thank you, sir.
Sir,
Good
we
afternoon,
have
sir.
Yes, second girl.
Good afternoon, sir.
Good
This side, Dr. Suman Gimal. So I have a question. It is observed in the district court so many times declared no work day just because of the demise of the any advocate. If a bar consists more than 500 vakils and advocates, and these problems will remain the same. So, and if we will declare no work day for that, so how case will be sorted out?
सर मैडम ये प्रॉब्लम आपके यहाँ ही नहीं है, सारे हिंदुस्तान में है। मैं लॉ कमीशन के चेयरमैन थे डॉक्टर एस.बी. चौहान, और मैं भी लॉ कमीशन का मेंबर था। तो आपको याद है वहां एक बिल आया था, लेकिन बाद में बार एसोसिएशन ने उसका बहुत विरोध किया कि नहीं जी स्ट्राइक पे बैन हो, ये हो। यानी आज वो विषय में उसमें नहीं जा रहा। मैं समझता हूं कि हमें भी लॉयर्स को, लॉयर्स बॉडीज को इस मामले में बहुत फर्मली डील करना पड़ेगा। डॉक्टर चौहान ने उस समय, हमने लॉ कमीशन में इंफॉर्मेशन मांगी और हमको ये पता लगा कि कई बार एसोसिएशन में 365 में से 290 दिन, 285 दिन, 280 दिन स्ट्राइक है, नो वर्क। छोटी सी बात, एक लॉयर आ रहे हैं, रास्ते में पुलिस कांस्टेबल ने रोक के उनका चालान कर दिया, वो सीधे बार रूम में आए, बार ने स्ट्राइक डिक्लेयर कर दी। मैं इलाहाबाद जाता था, एक इलेक्शन पिटीशन थी हमारे प्राइम मिनिस्टर के अगेंस्ट 2014 में और 2019 में, तो मैं वहां उस केस में उनकी तरफ से पेश होने जाता था। और 10 में से 4-5 बार जब वहां जाते थे, पता लगता था कल तो स्ट्राइक हो गई है। क्यों? वहां एक डिस्प्यूट चल रहा था। कुछ लोग कह रहे थे कि इलाहाबाद हाईकोर्ट का बेंच एक मेरठ में आए, तो अगर किसी का स्टेटमेंट आ जाता था कि हाँ इलाहाबाद का बेंच मेरठ में जाना चाहिए, तो इलाहाबाद वाले स्ट्राइक कर देते थे। फिर को बीच में रिकंसाइल करते कि अच्छा नहीं जाएगा, नहीं जाएगा, कोई बात नहीं है, तो फिर वो मेरठ वाले स्ट्राइक कर देते थे। अब बताइए इसमें क्या ये स्ट्राइक जाने से इश्यू सॉल्व हो जाएगा? एंड वी आर प्लेइंग विद आवर क्लाइंट्स। स्ट्राइक होने से लॉयर का नुकसान तो होता है, लेकिन उतना नुकसान तो सबसे ज्यादा तो क्लाइंट का होता है ना। किसी की बेल है, किसी का इंटरिम ऑर्डर है, किसी का टर्मिनेशन ऑर्डर है। मुझे लगता है बार एसोसिएशंस को, हमारी फ्रेटर्निटी को खुलकर सामने आना चाहिए, और ये बिना किसी कारण के स्ट्राइक पे जाना। कोई बहुत सीनियर मेंबर की डेथ हो गई है, मान लो 1 मिनट के लिए उस दिन आप वर्क सस्पेंड करें, समझ में आता है। किसी सीनियर जुडिशियल ऑफिसर की हो गई है, टू पे रिस्पेक्ट। और मैं आपको बताऊं, हाई कोर्ट्स में स्ट्राइक होती है, नीचे नो वर्क होता है, सुप्रीम कोर्ट में कभी नहीं होता। सुप्रीम कोर्ट में वर्क होगा, चाहे बार ने, वहां की बार तो करती नहीं है नो वर्क डिक्लेयर, वहां पर काम होगा। आपने वर्क रखा है, सस्पेंड है, स्ट्राइक है, क्या है, दे विल असेंबल एंड दे विल डू देयर वर्क। देयर इज नेवर अ नो वर्क डे इन द सुप्रीम कोर्ट, एंड आई थिंक टाइम हैज कम टू फॉलो दैट in the high courts also and in all the subordinate courts also.
Thank you, sir. Thank you, ma'am.
Thank you, sir.
Sir, we have another question.
पूछ लो, go ahead.
Sir, question, have you ever encountered a conflict between your duty to the court and your duty to represent the union's interest to the best of your ability? If yes, how do you resolve and deal such conflicts?
See, in the court, I am a lawyer. I am representing Government of India. So there is no question of any conflict. I have to represent the Government of India, and I have to represent the point of view of the Government of India. Personally speaking, my views may be different. That's a different thing. And I never allow my personal interest to come into conflict with the Union of India's interest. As a lawyer, when we enter the courtroom, then I am a lawyer, officer of the court. I may have political affiliation. I belong to BJP, no doubt about it. But that is outside the court. In the court, as a lawyer, it's my duty, and I perform that duty to the best of my ability and capacity as per the requirement of the constitution and the legal system. No question of any conflict of interest between my interest or the interest of the government of India. I have no interest. My interest in the court is only that the interest of the government of India.
Thank you, sir. Any participant have any other question?
Yes,
Okay.
Akanksha Priya.
Sir, what is the most significant change you have observed in government litigation over the course of your career?
ऐसा अभी चेंज आने लगा, दो चीजें चेंज आ रहे हैं. एक तो जो तो पटिशनर साइड से है, उसमें तो ट्रिमेंडस इंक्रीज है वर्क का. आप एक एम्प्लॉय को एक सीट से दूसरी जगह ट्रांसफर करो, वो रिट में आ जाता है. आप उसकी एक कोई वार्निंग दो, कोई प्रमोशन रोको, कुछ रोको, वो कोर्ट में आता है. Petitioners litigation is increasing. When I joined the profession in 80, there used to be about 4,500 cases per year. Now they have crossed 25,000. That is one from the petitioner side. From the government side, earlier things used to continue, but I am now observing it. Government of India also, state governments also, after having their experience taking into consideration, they are now formulating the transfer policies, they are formulating the litigation policies, and they are trying to see to it that litigation doesn't increase unnecessarily because of their act and conduct. They should not do things which may ultimately encourage litigation in the courts. That change has come and it is coming, and I think in future this trend will be further accelerated.
Thank you, sir.
Thank you, sir. Thank you, sir. Sir, now I would like to invite Dr. Vikas Gupta for the vote of thanks.
Thank you, Dr. Rajneesh. Respected Shri Satya Pal Jain ji, Additional Solicitor General of India, Honorable Professor Vishwar Singh, Vice Chancellor, Honorable Professor Dr. Piyush Verma ji, Registrar, esteemed faculty members, dear colleagues, students and advocates. Good afternoon to one and all. It is my privilege and honor to deliver the vote of thanks for this truly enlightening special lecture. On behalf of Faculty of Law and Guru Kashi University, I extend our deepest gratitude to Shri Satya Pal Jain ji for gracing us with his presence and delivering an inspiring lecture on litigation, career as counsel for the Union of India, responsibilities, reflections, and the road ahead. Sir, your address was not just a lecture, but a masterclass in legal practice, ethics, and public service. You enlightened us on several pressing issues of the judicial system, stressing that one must be perfect in whatever profession he or she is in. You enlightened the importance of being alert and awake in the court, along with certain other factors, maintaining clarity about the cases and dealing with the emotional pressures that litigation inevitably brings. You also brought exposure to the change that is upcoming in the current judicial system. Through case references, including the example of the case of Vermaji and your practical advice to government counsels, you offered us a real-world perspective on preparing cases and conducting ourselves with responsibility. Your guidance on building a career in litigation founded on hard work, honesty, and integrity has deeply inspired all of us. The way you addressed queries with patience and precision was truly marvelous. We are also grateful to our respected Vice Chancellor, Sir Professor Meshwar Singh ji, for his vision and encouragement in creating such academic opportunities, and to our Registrar Professor Piyush Verma ji for his constant support in making this event possible. My sincere appreciation goes to our esteemed faculty members and the organizing committee for the dedication and meticulous planning which ensured the success of this program. Finally, I thank all the participants, students, colleagues, and advocates for their active involvement and enthusiasm, which added immense value to this event. Once again, thank you, sir, Shri Satya Pal Jain ji, for sharing your time, wisdom, and experience with us. We look forward to the privilege of welcoming you again in the future. Thank you very much, sir.
Thank you, Dhanyavad.
Thank you, sir.
We've had a fantastic turnout, sir. Thank you so much for your time.